All right. Hello and welcome to the Nevada Legal Services Now live stream of our foreclosure presentation. I am Ray Gertkin with the Reno office of Nevada Legal Services, and I have with me David Olshan.
Hello.
And we are going to talk about foreclosures, foreclosure moratoriums, and essentially how to avoid it. So before David gets started, I just wanted to provide the disclaimer that the information contained in the presentation is provided for educational and informational purposes only and should not be construed as legal advice or as an offer to perform legal services on any subject matter. And I would also like to thank Denise with Captions Unlimited for providing our closed captioning for this presentation. So thank you very much. And David, take it away.
All right, so we're going to go through some of the policies that are in place to help you save your home, some of the strategies that you can use to save your home. And we've been through this. Advocates at Nevada Legal Services have been through this before in 2009, the Great Recession. And one of the things that we sort of figured out is that some people feel overwhelmed during these situations. So we would encourage you to try to rise above it and realize that saving your home is really important, because proactive acting to avoid foreclosure is sometimes a lot easier than reacting. When you get those notices, sometimes you think all hope is lost. So we're just trying to provide a gentle reminder that sometimes getting out ahead of these and figuring out what you want to do is better than reacting once you're in a difficult spot. So the first thing we're going to talk about is the foreclosure moratorium under the CARES Act. Currently, if you have a federally backed mortgage, you have a 60-day moratorium that ends on May 17th, which is this Sunday. So you don't have to do anything. If you've been paying your mortgage, good for you, but you really didn't have to. And this automatic moratorium ends on May 17th. However, if you do have a federally backed mortgage, you can get 180 days, 6 months, and another 180 days. So it's basically a full year of forbearance. Now, forbearance means you don't have to make a payment. You will not be charged any late charges, but interest continues to accrue, and you will not have any adverse credit reporting as a result of this forbearance. So when I talk about a federally backed mortgage, I'm talking about an FHA, U.S. Department of Agriculture, VA, Freddie Mac or Fannie Mae. I kind of combined them. But if 70%, I'm talking about 70% of the mortgages out there. So there's a good chance you do have a federally backed mortgage and you would be entitled to this essentially 1 year forbearance. Of course, this financial hardship that you're under has to be related either directly or indirectly to the COVID-19 crisis. If we could, oh, there we go. All right. So if this is a single family home, 1 to 4 units, like I said, there's a 360-day forbearance. If you own income property, a multifamily housing, you can get a 90-day forbearance. And what the CARES Act and the indication that we have from some of these government agencies is that these forbearances could be as easy as a phone call. So again, it's better to act proactively. For the 1 year forbearance or the 90-day for multifamily, you have to actually do something. You have to call, you have to fill out an application. There's minimal documentation that you need. And if you do that, you will have a year for single family and 90 days for multifamily to go without paying your mortgage. So this program under the CARES Act will end after the state of emergency ends or December 31st. So we're currently federally under the state of emergency, so you can take advantage of it, but I don't think it's going to continue for very much longer. So take advantage of your forbearance under the CARES Act. If you need help, there's a link, and we're going to attach these under this live stream to help you see if you have a federally backed mortgage. But this is one benefit that is fairly easy, and if you need this help, you should apply for it. Wow. So these are some other links to figure out some of these government agencies like the FHA, Fannie or Freddie will have additional benefits. Like Fannie has already submitted this directive that when you do have to pay back the mortgage, they're not going to ask for the money in one lump sum. They will collateralize it, that will add it to the principal. So you might have a higher payment when you get off the forbearance, but it won't be something insurmountable. You won't have to pay the total forbearance amount back, which is very difficult for some people, as you can imagine. It's a year's worth of mortgage payments. But if you do have questions regarding, like if you have a VA loan, there's a link there, and there's other benefits that these federal agencies have. So you should go and check and see if you have, like if you were worried about a lump sum at the end of the forbearance, Fannie's already taken care of that.
Well, and it's true, just to remind people that you do need to talk to your servicer. None of these options are really just going to magically appear. So you really just, one of the things we're going to talk about throughout this is really reaching out and talking to them. Because after the forbearance period, as David said, one of the things that can happen is your lender can enter into a modification. So there are a bunch of programs that you can be essentially eligible and considered for. So at the end of the forbearance, reinstatement is an option. If you have the ability to reinstate, you can do that. But if you don't have the ability to reinstate, meaning pay off whatever is left over at the end of the forbearance, for federally backed mortgages, they should be evaluating you for different modification options. So keep that in mind, that even if they want you to reinstate, if you have a federally backed loan, that is not required. If you can't afford to do that, then you can be eligible for different modification options depending on your circumstances. One is if you can pay the current principal and interest, they capitalize the arrearages and then potentially spread out the loan over additional terms, but essentially your payment can remain the same. And if you can't afford your payment, then you can go into more traditional modification options to try to work something else out to get your payment lowered as well. So you have to talk to your lender about this. They're not going to just give it to you after the forbearance is over. You need to be making these requests.
And yes, I misspoke. It should be capitalized, not collateralized, but anyway.
No, I think that I certainly understood what you were saying, but I just think it's important that one, people understand you have to reach out to your servicer, but two, we are only talking about federally backed loans, right? So, I mean, if you're in the 30% that's not federally backed, these options might not necessarily apply, but almost all servicing agreements have potentially some workout option. I guess I shouldn't say almost all, but there might be workout options that you should be asking for.
All right, so if you are caught up in not paying your mortgage, the moratorium here in Nevada ends, you will be facing a foreclosure. So we're going to talk about the foreclosure process and the notices that you get. Again, if you get a notice of default or you get this omnibus notice, I'm calling it omnibus, but you'll get a notice 30 days prior to the notice of default. So at that point, don't panic. Don't be overwhelmed by the barrage of notices, because there is something you can do. There's usually a foreclosure alternative, so don't lose hope. And it's, you know, of course, it's easy for me to say, but it's really important. If you do want to, what's going on? Anyway,
All right, you talked about barrage and notices, and you actually have a slide that says that. So I was just hoping it was the next one, but it's
no,
not.
it's what is that called? Anyway, so 30 days before the notice of default, there's a notice that's provided. You do have these foreclosure alternatives. If you don't participate, then 30 days later, you'll get the notice of default. You will get 3 months until the notice of sale. You get other notices, a whole bunch of them. Affidavit of authority to exercise power of sale, mediation notice, trustee contact information to the HO. Look, you're going to get a lot of stuff, but some of them are important and some of them are not. So to proceed with the foreclosure, you're going to get the notice of default because that officially starts the foreclosure process in the state of Nevada. All right. The notice of sale, again, comes 3 months after the notice of default, and they must publish it once a week for 3 weeks. So you get 21 days under the notice of sale. When they are advertising, they're giving you a sale date. So you're going to see in the notice of sale when your property is going to be sold. Once it is sold, or the bank takes it back, then you're going to get notice of that fact. Once it is transferred, once the title is transferred, there's a 3-day notice, and that's followed by a summons and complaint for unlawful detainer. Now, because you're getting so many notices, you may miss that 3-day eviction notice. That's an eviction notice. So you're no longer the owner of the house, and you really need to address that, or you will be evicted. So typically when the bank forecloses, they do follow the proper procedure, and there's not much that you have to defend. And if you come in at the last moment with the 3-day notice or the summons and complaint, you're really in a difficult spot. So that's the end of the process. The summons and complaint for unlawful detainer, you will very likely get a hearing within 21 days. I think that's the Supreme Court rule. But once you go to that hearing, the judge is going to decide whether a writ of restitution should issue. And at that point, you're going to be evicted. Okay, don't panic is what I said before. These are the important notices. There's going to be 30 days notice, advance notice before the foreclosure starts. There's going to be a whole list of things that you can do, foreclosure alternatives. Open your mail. That star is showing and it's blinking. Or is that just my eyes?
No, it's blinking.
Blinking.
I just think people get overwhelmed, right?
Yeah.
I mean, you get multiple copies of the same thing too, which I always caution people, you have to open everything. Don't assume that what you're getting is just multiple copies of the same thing. They are required to send you things like the foreclosure mediation information. So you need to open up all of your mail. Don't ignore it because it will just make it worse. Because as David said, if you get that 3-day notice of eviction, you no longer own your home, and there may or likely is nothing you can do about the foreclosure at that point.
And one of the things that I think it's the most important thing I learned from law school is if somebody's trying to serve you and you run away, that's really not a defense. So I think there's like this idea that if you put your head in the sand, avoid service or avoid the mail, these problems will go away. No, they don't go away. In fact, the legal process continues without you. So it's in your best interest to open the mail and figure out if you want to contest this, if you want to save your house, you got to do something about it. It's the same thing with getting served. You don't want to avoid service. You want to accept service because that gives you more time. If you don't accept service, they just serve by publication and no one knows. So you don't want to avoid service or avoid this mail. It has a lot of important information. It is a reminder that you're going to possibly lose your home, but that's a tough reality that you need to face. So the 30-day notice is followed by a 3-month notice of default. And during that time, if you want foreclosure mediation, the first 30 days, you have to request it. If you don't request it, The foreclosure continues. If you don't have anything to offer, you still might want to request it, because what a foreclosure mediation does is it delays the foreclosure. So sometimes I don't have any money, I don't have any ideas. Well, you still have the right to request mediation. But if you don't, then, well, anyway, you get the 21-day notice of sale, and then the eviction happens. Okay.
So I'm trying to anticipate when you're going to
I
move
know,
on.
I'm sorry.
It's
The
all
saying next every time is also kind of,
right. I know.
all right, so.
Essentially the process, I guess the bottom line is the process can take a while. Open your mail. When you start getting notices, the first couple of, the first notice is going to talk about the foreclosure alternative process. These are all time periods where you can try to work something out with your lender. So as David said, 30 days prior to the notice of default, the servicer has to offer foreclosure alternatives, and they're required to reach out to you. In fact, under Fannie and Freddie servicing guidelines, they're required to reach out to you. Now, this also means answer your phone, because if they make a couple of attempts to call you and you just don't answer your phone because you don't want to deal with it, then that's going to be enough, and you're going to lose out on some of these potential alternatives to the foreclosure process. It will also delay the foreclosure and buy you more time if that's what you need to sort of get back on your feet.
And many times you feel that all hope is lost. And if you talk to a good employee, and sometimes they're not good, but sometimes they just want the money, but sometimes they will offer you ideas and options that you haven't thought of. So even if you're not answering the phone, creditors are calling, you're being harassed, answer the phone for the mortgage company, because it's important. We can't stress that enough. Okay. Foreclosure mediation. All right. We could talk about the application. Generally, it only applies if you're in a single family residence, and that's a fourplex or less. But what I see and what I've seen is that sometimes you'll be eligible for mediation, even though the statute doesn't allow you to request mediation. So you request it anyway. But yes, it only applies if you're 4 units or less. If you own multifamily housing, no, mediation isn't available to you. Also, if the lender has foreclosed on less than 100 owner-occupied properties, or if you're not dealing with a bank or a financial institution. So usually you will get the opportunity to ask for mediation. I think these subtleties are not really, most servicers and banks really don't care about it. They'll just offer mediation. Ray, is that your experience, or?
Yes. Yes. I mean, most of the time mediation is usually doable. And certainly in times where there's a lot of foreclosures happening.
Right. They just don't have the time to separate out the ones that are eligible from the ones that aren't eligible. The point here is if you're eligible for mediation and you'll get the notice that informs you of the right to request mediation, and you want mediation, you should request it. You can't say, well, this is technically a 5-plex because I'm renting out the garage. No, you don't say that. Apply for mediation.
Yeah, and let them come up with the excuse why you're not entitled to it, because you'll have the chance to. I mean, right, the new foreclosure process is, we'll get into this, but you're filing a petition in court. So essentially a judge would have to make the determination of whether or not it qualifies or not.
Right. We can go forward. All right. I mean, generally speaking, yes, the bank, the servicer, is going to send you notice. It's going to contain a whole lot of information, the amount of deficiency, the amount to cure the deficiency, the the data on the mortgage, including how it's been transferred and who it's been transferred to. The lender, the servicer has to provide authority that they can do the foreclosure. So, a long time ago, there was this Deutsche Bank argument that if the servicer didn't have the note, didn't have the mortgage, they couldn't foreclose. Well, state law kind of has incorporated the Deutsche Bank defense. So the lender will have to come to the table with authority to foreclose and authority to act upon the mortgage. There's going to be a copy of your payment history, and you can check whether your payments have been credited to the account. Many times banks will put payments in suspense if they don't know where it's going or if it's an irregular payment. And sometimes that suspense account can hold a whole bunch of money. So you want to figure that out. Have your payments been credited to the debt? And if not, then that also would help you, because the bank, the servicer, is holding a whole bunch of your money and not assigning it to principal or interest or anything else. So, you should look over these documents, figure out whether your payments have been credited, figure out whether the amount that you owe is the actual amount that you do owe. So the notice of the right to petition, foreclosure mediation, you used to send it to the Supreme Court, now you send it to the local court. You're requesting mediation. And again, you're going to get that probably with your notice of default. And if you want to try to mediate with the lender, or you want to try to delay the foreclosure, you're going to request mediation. So oh, here we go. Yeah, no. So when you request mediation, you have to include $25 filing fee plus a $250 fee for the mediator. Ray, help me out. You can't request a fee waiver, right? Because if you don't have that money.
You can't, not for the $250 fee.
Okay, but for the $25 fee?
I think you can, but it is $25. So if you do request a fee waiver, I think you need to come up with an argument about why you need to waive the filing fee, but can still pay your mortgage if you're requesting mediation, or a reinstatement option, not a sale option.
Yeah, I would just think if you're filing for a fee waiver, you don't really are not entering the negotiation with good faith. But there could be circumstances. So why say no? Just say maybe. So yes, you can waive the $25, but you will have to pay for the mediator. You have to serve the beneficiary. Home Means Nevada. We're sending it to Home Means Nevada because they keep stats. I mean, why are we sending it there?
They keep stats, and they also are the ones that notify the trustee and then issue the certificate, right?
Oh, right. Okay. All right. Well, but I mean, basically, you're following the instructions that you get with the notice of default, or in many of the documents that are sent by the lender. So also keep in mind that we here at Nevada Legal Services can help with mediation. So if you are overwhelmed and need an advocate, we're here to help.
Yes, and we didn't mention this before, but I feel like this is a good time. If you have any questions or anything that you would like clarification on, please put that in the live chat, and we will address it either during or after the presentation. So we will definitely be more than happy to address it during this presentation, or if it's something that you think we can help with, or you want to talk to someone, you can call us as well.
All right, so I mean, I think the thing that people should know is that, when you go into the mediation, I think we need the next slide, or did I miss something? I mean, typically these mediations will not work unless you have enough income and or the prospect of income to get back into making regular payments and addressing the arrearage that has built up. So you're going to be much more successful if you do have income or you have the prospect of income, or instead of, your hours are getting cut or you lost your job. But again, it shouldn't, even if you want to delay the foreclosure or talk about a short sale or a deed in lieu of foreclosure, you can still request mediation. I mean, do they still say if you want that, it's not good faith?
I'm not aware of that. I mean, the BPOs are still required documents from the beneficiaries. So I don't see why negotiating a short sale would be considered, I guess not bad faith, but not good faith. But the biggest problem is that the banks don't negotiate short sales. They will say that you have to put it up for sale and see what happens. They won't really allow time to do that. But I don't see why you couldn't do the mediation process to get all of that information from the lender and try to work something out. I mean, is it not good faith for the lender to not talk to you about a short sale? That's a possibility.
Well,
I don't think it's going to work. I mean, don't argue that it's bad faith, but I don't see why you couldn't request mediation if you don't really have the income to support a modification and you're just looking at the best way you can to get it out.
I think it's probably worthwhile just to request mediation to see if the servicer shows up, like there's always a possibility that they won't show up and they can't go forward with the foreclosure.
Right.
I mean, look, anything's possible, but you shouldn't be hampered by, I don't have any money, I don't have any options. Well, you do have options. You can just get more time. Everyone needs more time when they're being evicted or having to move. So request mediation, and at a minimum, it's going to give you more time.
And not to be all doom and gloom with this presentation, but all indications are the problem with COVID-19 is not a short-term problem. So, the longer that you can try to stay in your house, the more time you get, the more time you might actually have to get a job or find ways to increase your ability to retain the house. So time is everything we're sort of talking about here is really to buy time to see what you can do. Now, if you do have the current ability to work something out, getting that arrearage amount higher and higher is not going to be helpful. So you do want to act quickly, but act quickly in order to try to negotiate a resolution.
Yeah, that's so true. I mean, one of the worst situations when you have income, but you don't have enough income. So, sometimes this is just like, I'm just doing it to stall and delay because, my new apartment, whatever, isn't open or other options aren't available, or I'd really like to work it out. I have this income. So, sometimes that income isn't enough. So those are, to me, the more difficult situation. Yeah, you're right. COVID, when is life going to go back to normal? We don't know. And I hope that lenders, servicers understand that and do offer greater flexibility, because typically it's like, give us the money or get out, like there's not a lot of room that banks offer to help people avoid foreclosure.
And just remember too, when you're in the mediation, all of those options that we talked about earlier with the CARES Act, that's basically the guideline of what you're going to be discussing at mediation and asking why they can't, why aren't you eligible for one of the workout options?
Right.
So back, in 2008, 2009, we had the HAMP standard. Now we have the emergency modification standard, the disaster standard. So, there are a lot of things, there are a lot of reasons to ask for mediation, especially if your lender says you're not eligible for something that you want.
The HAMP waterfall.
There's still a waterfall, and I guess that was my point sort of with the forbearance. That's just step one. There's still a waterfall, there's still modification options and other options. Still have to waterfall about a federally backed mortgage. And even like I said, private lenders too, they usually have servicing guidelines that have options in them. So,
Yeah, when we talk about a waterfall, we're talking about extending the term, um, capitalizing the arrearage. What is the waterfall? Man, I got right into it.
well, I'll just say this, we have the links in the description box below, but most of those documents will have the waterfall in them, so you can look
Right,
at
but
it.
I mean, there's basically three things that you do. I don't know the order at this time, but the idea was to lower the interest rate, to extend the period of the mortgage, and to take the arrearage and fold it into the principal. And that was the last step because the loan is less, it, it's going to be worth less if it's going to be worth more, right? Yeah, you're paying more in interest. Yeah, so if you capitalize.
All right, but as far as the petition process goes, just remember you're filing this in district court. The court then assigns a mediator. Depending on the court you're in and how often they do this, it can take a while for the mediator to get assigned. They usually do it pretty quickly. The problem arises is if a mediator recuses themselves. So just keep that in mind that the court is controlling this process, but they appoint a neutral mediator, and that mediator then controls how the mediation works. And then the mediator is going to speak with both parties to begin the document exchange. And the document exchange back in the day was where things went sort of sideways for the beneficiary, because the beneficiary has a whole host of documents they have to provide. I believe most of the kinks have been worked out, and beneficiaries these days are not violating the document exchange rules. But the homeowner is generally going to be required to fill out a loan modification loss mitigation packet. And that's what he's talking about in terms of getting these foreclosure alternatives, is to fill out the lender's packet to request the assistance. And that is also one, you're probably going to have already seen it because they're probably going to have already sent it to you. If you're talking about your options, this is an answer to your information to request the alternatives. And then the beneficiaries respond, you can respond their response for information, and then they may or may not offer you a modification before the mediation even takes place.
But I mean, it goes back to the sort of Deutsche Bank, because state law now requires those documents. Usually the lender will have them by the time the mediation happens.
Yeah, I mean, we're not in the days where banks don't have the notes and things. They have the documents now. But these are all the documents that the beneficiary has to provide. And if they don't provide them, technically the foreclosure should not continue. But, again, we're seeing less and less that they don't have them.
Yeah, and there's the infamous case. Wow. Anyway, the infamous case where the broker, the BPO, was like more than 60 days old. So somebody took that case to the Supreme Court. I think those days, like you said, are over. That these technicalities sometimes, they're looking at the big picture. And if you don't have authority, if you don't have those documents that allow you to foreclose, I think there's going to be self-policing. So the bank probably wouldn't go forward. But it's like, if a BPO is more than, it was like 65 days old, I mean, those minor technicalities probably aren't going to get you, aren't going to stop the foreclosure.
Definitely not these days.
All right, 4 hours for mediation. Generally, they're during working hours. Generally, there's no chance for a continuance. So if there is a suggestion for a mediation time, make sure you can make it. You have to exercise good faith when you enter the mediation. And we talked whether a short sale was good faith. It is. And I don't think that's going to be a problem. I think also a mediator, My impression is most of the mediators are not too motivated to work too hard in these mediations. I guess that's a nice way of putting it. So, I mean, you got to do a lot of the work. You got to do the suggestions. And if you're sort of looking for a mediator to take control and hold a bank's or servicer's feet to the fire, that usually doesn't happen. So like if you are unrepresented at these mediations, I think it is a problem because oftentimes you don't know what's available and what, you know, the servicer is required to do.
And mediators aren't really allowed to force either party to do anything. I mean, that's kind of, mediators are just there to facilitate a discussion. So, you know, mediators have different ways that they preside over mediation. Some are a little bit more forceful than others, but generally speaking, they can't force them to. They can help, but you should know what your, you know, your options are, and be prepared to ask questions and ask why you can't qualify for options, because mediators are just there to help facilitate a discussion.
And generally in these situations, you're looking at a mortgage payment that's about a third of your gross income. So many times there's no chance for mediation because that mortgage payment is going to be 70%, 80%. That's not sustainable. That's not feasible. So, you know, going into this, you need income. You need income to pay the mortgage.
But the standard is good faith, and just so everybody knows, I mean, good faith is not a really high standard for the bank to meet if they show up, essentially.
Right. So if there's an unfavorable result or you don't request mediation, the foreclosure continues. There will be a certificate issued. And what follows, if the 3 months have expired, then there's a notice of sale.
And the sale happens essentially on the courthouse steps. You know, it's just basically an auction, and there are people there who bid on homes. So you can attend the auction, and but you know, it's not going to happen in any, you know, the court doesn't control that. Once the mediation is over, you don't request it, you know, the court's out unless you appeal it.
I mean, how is that going to continue under COVID? And if more than 10 people show up, then you're not complying with the COVID.
It is outside, so I guess you can socially distance.
All right. So, all right. So one of the ways to change this power dynamic, because generally homeowners are going into this are less powerful than banks or servicers. And one of the ways you can sort of equal or try to equal the power is by filing for bankruptcy. And when I'm talking about filing for bankruptcy, I'm talking about a Chapter 13, because a Chapter 7 won't really do much to save your house. In fact, it won't do anything unless you sign a reaffirmation agreement and pay what you owe. You're kind of like out. So if you want to save your home, you owe a lot of money. You have to, and the bank won't work with you. Sometimes they might be like a non-federally backed, so they don't care. It might be some back alley type of financing situation, which does happen. You might get, you know, money lender. The point is, when you go into a Chapter 13, you're pretty much on the same level. So you don't necessarily worry about whether the servicer will agree. If the payment plan is feasible, the bankruptcy court will approve it, and that's your mediation. That's your payment plan. So to file successfully in a Chapter 13, you need regular income, and that this regular income, can you go back? Sorry.
Yeah, I don't know what happened.
That's all right. The regular income has to exceed your expenses. Okay. That's one of the things you need. You need income that's more than your expenses. You also need to look at the total amount that you owe and if you can pay that back over 60 months. The longest time, well, during this COVID crisis, you get 7 years. But we're going to talk about normal time, which is 5 years for a payment plan. That's 60 months. So if you owe $60,000, let's say, you're going to have to pay $1,000 a month plus the other expenses. And if your income is not high enough, you're not going to have a successful payment plan. So Chapter 13 won't be for you. If you are close to having income that doesn't exactly exceed your expenses and your arrearage that you owe, you can still qualify, because in a Chapter 13, you can strip unsecured liens that are on the home, second mortgages, home equity loans, things like that. So that's going to lower your payment. You're going to lower your expenses. You can also lower the payment on your car. It's called a cram down. So you can lower these expenses and still have a feasible payment plan, because once you do those things in a Chapter 13, your monthly expenses are going to be less. Also, Chapter 13 has mortgage mediation. They've had it for a while. It's very successful because when banks, servicers come into the Chapter 13, there's no question about whether the debtor, the homeowner, will file a bankruptcy. They've already done that. So I think a lot of the extra power that a servicer has is knowing there's no consequence. Well, the consequence of the Chapter 13 is this payment plan is going to last 5 years. So there's incentive for the servicer, the bank, to negotiate in a Chapter 13 in mortgage mediation. And sometimes you can wind up with a very good deal, a deal that you wouldn't necessarily get without filing the Chapter 13. All right, so what we want people to do if they want to figure out if Chapter 13 is right for them, you're going to take your gross income, and this is your gross income that's averaged over the last 6 months, and you're going to divide that up by 6, which would be your monthly income, and then you're going to multiply that by that amount by 60, because that's how many months are in your 5-year payment plan. So you want to figure how much income you're going to devote to this plan over the life of the plan, which is 5 years. So we're going to take your 6-month income, divide by 6, and multiply by 60. Then you're going to take your living expenses, and you usually have your monthly living expenses. And you were talking about food, mortgage, utilities, transportation, car payment, gas, insurance, etc. You're going to multiply that by 60, and that's going to be the total amount that's coming out of the payment plan during the life of the plan. So you're going to take your income, you're going to subtract out your expenses, and you have to have a positive total. If the result is positive, you're going to have a chance to get a feasible payment plan and succeed in a Chapter 13. Once you get that positive result, you're going to add up your mortgage arrearage and subtract that out as well. And hopefully you'll still have that positive result, because then you definitely have a good chance of having the court approve your payment plan. So here's the example. And we're being very general here, and we're not really getting into the weeds, because this is just a determination of whether Chapter 13 is right for you. So your six-month average income from a job is $7,200. You also are renting a room in your house to a boarder, and so you're getting $200 a month, so that's $1,200. So that's $8,400 over 6 months, or $1,400 over a month. You're going to times that by 60, because that's the length of the plan, 60 months, and you're going to come up with $84,000. So $84,000 over a 5-year plan, that's what you're going to pay into it. Now, if you take your monthly expenses and times 60, let's say they're $890, times 60 is $53,400. So again, I'm making this up. This is a hypothetical, but this would be a very good situation where your income is substantially higher than your expenses, and you're left with $30,600. You take your income over the life of a plan minus your expenses over the life of a plan, and it leaves you with $30,600. So let's say you haven't paid your mortgage in a while and you have $15,000 arrearage. That $15,000 is less than the surplus you have. So this plan would be feasible. And this is a positive example. I wanted to do that. And sometimes it's not that easy to have that positive balance. But if you're anywhere near a positive balance, like I said, you can lien strip, you can cram down, and you can qualify under Chapter 13 for your payment plan, and it can work. The real point here is I'm speaking in general terms, and to actually see if you qualify, you should talk to us at Nevada Legal Services or an attorney that specializes in bankruptcy, because they can tell you specifically whether you will qualify.
And just to contrast the 13 and the 7, in a Chapter 7, you have an income test that looks at the higher end of your income. But in a Chapter 13, you're really looking at the lower end. Do you have enough income to enter a plan? So in a Chapter 13, is there an income limit? Can you have too much income?
No. When you're talking about a Chapter 13, you're talking about debt. So like for unsecured debt, I think the limit is like 300,000, and for secured is like 1.2 million. So in a Chapter 13, you're worried about the debt limit. In a Chapter 7, yes, you are worried about your income. So if you're over the median income, you're going to be pushed into a Chapter 13. But when you're talking about this plan, you're trying to be as realistic as possible. And you don't want to shortchange your expenses, because you have to stick on this. The budget is for 5 years. Now, if you've ever tried to stay on a budget, it's difficult for a lot of people. You get sick, you get less hours, just things happen. And so if you can't make these payments over the 5 years, you're going to fail, and the Chapter 13 is going to be converted to a Chapter 7, or your case is going to be dismissed. So what we're worried about in a Chapter 13 is your debt, and we're not too concerned. If your income is high, that's going to be very helpful. So again, we're speaking about all these issues in general terms. If you have a problem, if you want to know if Chapter 13 is right for you or what's the foreclosure process, give us a call, because we do this work all the time and we can provide legal assistance. I do not know if are people asking questions or
No, so far there's nothing in the chat. So, if you do have something that you want to ask, get it in the chat as soon as you can before we end. But so far, nothing in the chat.
Right. And one thing I didn't mention, because it's probably going to end soon, but currently in the state of Nevada, Directive 8 stops all foreclosures until the state of emergency ends. We believe the end of the state of emergency will be soon. So like I said, under the CARES Act, that moratorium ends at the end of the year. That's a better moratorium. However, you do have to request that forbearance. Then you would be eligible for not making a payment till the end of the year.
And again, as always, if there are any other topics as well, go ahead and comment or put a suggestion in the chat, because we do a lot of things. Next week, we're going to do an unemployment benefit presentation. So we can potentially help with a lot of different things if, there are a lot of things going on in your life right now.
Right. One other thing, sorry. We do have bankruptcy Chapter 13 videos on our YouTube channel. So I speak generally of a Chapter 7 and a Chapter 13. I go into the payment plan with more detail, and I go into lien stripping and cram downs. So if what I said, you're not understanding it, try one of those other videos, because they do explain the process in a little bit more detail.
All right, but I think that'll do it for today. Again, I am Ray Gertkin with Nevada Legal Services in our Reno office, and David Olshan is in our Las Vegas office. Again, want to thank Captions Unlimited for providing closed captioning for the presentation. Presentation today. But that'll do it. But again, feel free to contact any of our offices if you have additional questions. Thank you, David.
Thank you. We're not live anymore? Or?